Welcome to our update from the ICANN77 meeting in Washington D.C. I'm Ashley Roberts, and we're going to spend the next 15 minutes summarising the updates from the ICANN meeting. The topics we're going to cover are the next round of new gTLDs, DNS Abuse Developments, and the Registration Data Request Service, or RDRS. So I'm going to start with the next round of new gTLDs. If you watched our update from the ICANN76 meeting, you'll have heard us explain how ICANN and the GNSO Council were working together to try and resolve the remaining open items that were dependencies for the next round. One of those key issues is closed generics. Now, as a reminder, the question of whether to permit closed generics in future rounds was debated at length by the Subsequent Procedures Working Group. Unfortunately, they were not able to reach a clear solution on whether and to what extent closed generics should be permitted. So as a result of that impasse, in November 2022, a facilitated dialogue on the topic of closed generics was initiated. That discussion group had the aim of trying to develop a framework that would outline the circumstances under which closed generic TLDs might be permitted in future rounds. The discussion group included representatives from three groups: the GNSO, the GAC, and the ALAC, and the group has been facilitated by a professional mediator employed by ICANN. After a number of months' work within that group, just prior to ICANN77, they published their draft framework for closed generics. That framework is currently open for public comment until the 15th of July. In terms of the substance of that framework, in a nutshell, it requires that any closed generic TLDs in future rounds would need to serve a public interest goal. So the applicant for a closed generic TLD would have to explain in their application exactly how it would serve a public interest goal, and then that explanation and argument would then be evaluated by an ICANN panel to determine whether it meets the public interest criteria. So unsurprisingly, there was a lot of discussion of that framework at ICANN77. It was discussed amongst a range of groups in lots of different sessions. But of particular note was the discussion of the framework within the GAC. There were a number of GAC members, particularly from certain European Union countries, that expressed dissatisfaction with the current state of the framework, and they expressed skepticism about whether they would be able to approve the framework in its current state. The GNSO Council, for their part, have said that if the framework is approved, then they would look to initiate a policy development process which would take that framework and develop it into binding policy that would apply to gTLD registry operators. However, it remains to be seen at this stage whether the community will actually approve the framework or not. The other topic, open topic related to new gTLDs that I want to cover today is PICs and RVCs. So as a reminder, PICs stand for Public Interest Commitments, and they were created by the ICANN board during the last round of new gTLDs in 2012. The PICs were created as a mechanism to allow applicants that had received objections or kind of concerns from governments to try and address those concerns. So it allowed them to put particular commitments into their contracts to make them binding that would specifically address concerns of governments about their TLDs. Because those PICs were introduced quite late in the day and by the ICANN board directly, when the Subsequent Procedures Group were doing their work in the last few years, they made a recommendation to formalize the concept of PICs for future rounds as well. And they also introduced a new term known as registry voluntary commitments. Registry voluntary commitments is essentially interchangeable with public interest commitments. Really what it's specifically referring to is the voluntary element of these, so those specific commitments that a registry operator decides to put in their contract. So yeah, the subsequent procedures working group had recommended to formalise and continue this idea of PICs and RVCs in future rounds. However, the ICANN board, when they came to review the subsequent procedures recommendations, they identified this particular recommendation as problematic. Their particular concern was around whether they could enforce certain PICs. There was a worry that certain PICs or RVCs might creep into the area of content, and ICANN specifically prevented in its bylaws from dealing with anything related to content regulation. It's outside of its mission, so that was where their concern came from. So as a result of that concern, there'd been some discussion in the lead up to ICANN77 and in the first few days of the ICANN meeting. And there was a suggestion that the ICANN board might look to amend its bylaws to create a carve-out for PICs and RVCs insofar as they relate to content. However, as we got further into the meeting and there was more discussion, the board seemed to cast doubt on this idea of amending their bylaws as something that would be undesirable and potentially unfeasible, now that it not only requires the board to approve bylaws changes, but it requires the broader ICANN community to rubber stamp bylaws changes, and it's not clear whether the community would actually rubber stamp such a change. So instead of a proposed change to the bylaws, what we heard from ICANN board members Becky Burr and Davri Doria is that they would prefer a solution whereby any applicant wanting to include a PIC or an RVC in their ICANN contract would at the same time need to explain exactly how that PIC or RVC would be enforced, and then that explanation would have to be, evaluated by the ICANN board. It would really be a kind of negotiation between the two parties. That idea is still in its early days, and it's still under discussion, but we'll keep you updated on how that develops. And lastly, I just want to finish by turning to timing for the next round. So we're still anticipating that ICANN will publish a tentative date for the next round at the start of August, and that's when it's due to provide its new gTLD implementation plan. So as and when we hear anything on that, we'll update you.
So we'll now have a look at DNS abuse and the developments that happened in the lead up to and during ICANN77. Right before ICANN77, the INTA board adopted an alternative definition of DNS abuse. Any activity that makes or intends to make use of domain names, the domain name system protocol, or any digital identifiers that are similar in form or function to domain names to carry out deceptive, malicious, or illegal activity. This is different to the one that is currently being discussed within ICANN, which is just malware, phishing, botnets and farming, and spam, where spam is used as a delivery mechanism for the first four categories. The INTA definition does reflect the broader concerns of brand owners and businesses with the definition put forward, specifically that listing types of abuse does not account for evolving methods of perpetrating harm online. However, it is unlikely that the INTA definition would be adopted by ICANN moving forward, given that it goes beyond the DNS to consider other types of identifiers. Also in the lead up to ICANN77, PIR's DNS Abuse Institute published its June Compass data, naming registrars and registries with the highest and lowest rates of maliciously registered domains per 100,000 under management. The Institute only opted to name registries and registrars with high rates of maliciously registered domains if they appeared with the highest observed rates per 100,000 domains under management for 4 or more of the last 6 months. Registries and registrars initiated contract negotiations with ICANN at the end of 2022. For the first part of 2023, registries and registrars have been working with ICANN to negotiate new language for the contracts to raise the floor for handling reports of DNS abuse. These proposed amendments are currently out for public comment. The proposed amendments also come along with an advisory from ICANN intended to further explain the proposed amendments to make sure that registries and registrars will have sufficient guidance to implement the language and other people can understand what their obligations actually will be. The proposed amendments are aiming to require registries and registrars to provide confirmation of receipt for reports of DNS abuse and to take appropriate mitigation action for evidence reports of DNS abuse received by registries and registrars. In some instances, appropriate mitigation action will be suspending the domain. In other instances, it may not be appropriate to suspend. For example, where the domain supports critical infrastructure unrelated to the abuse. For instance, a domain supporting the main website of a business, it would not be appropriate to suspend this domain as it would take the whole website offline as well as any emails associated with the domain. This is in comparison to a domain which is being used purely for just a phishing attack and has nothing else related to it on there. It would then be appropriate to suspend that domain. These amendments, as mentioned, are currently out for public comment until 13th of July. We encourage you to have a look through these proposed amendments and see if there are any possible changes you would like to suggest or if you are comfortable with the amendments.
I'm going to give an update on the Registration Data Request System, or RDRS. This is a system being developed by ICANN to act as a centralized portal for submission of requests for disclosure of non-public registration data. So that's the data that we formerly called WHOIS, and which is now masked as a result of the implementation of GDPR. The development of the system is on track. It's due to go live by the end of the year, so 2023. Registrars will be able to start signing up in August, and then brand owners and their legal counsel and law enforcement will be able to start using the system from late November. To recap on what the system is, it will be a free intake and ticketing system for disclosure requests. These will then be channeled to the relevant registrar for the domain name. Any verification of the requester or the legal basis for the request that the registrar considers to be necessary will happen outside of the system on a one-to-one basis. There's no guarantee that when you submit a request you will get the data disclosed. Each registrar will make its own assessment of whether the disclosure is permissible under the law. When they do so, they will channel the response direct to the requester. It won't be sent back via the system, and this is to cut down on the data that's being transmitted to ICANN. The registrar is expected to indicate in the system, however, whether they disclosed the data and their reason for any refusal. As currently being developed, the RDRS will only deal with disclosure requests being submitted to registrars and not to gTLD registries. And it won't be compulsory at the moment for registrars to participate and use the system. During discussions at ICANN77, however, most of the registrars present, which includes the larger registrars with a large proportion of the market, did indicate that they do intend to participate. We also received a confirmation from the ICANN staff developing the system that it will include a template function so that requesters can save regularly used information as a template for reuse. It's hoped that this will go at least some way to reducing the burden for those who submit multiple requests. The real purpose of this system is to gather data on the demand. And the idea is that this will then help to inform the ICANN board's decision on whether to invest significant funds in building something more complex that potentially would include something like upfront verification of requesters and assessment of the legal bases for request. It's therefore intended to operate this system for 2 years, or possibly sooner if there's clear data available sooner than that. But assurances were given in DC in response to some concerns that it's not the intent to just switch this system off at the 2-year point. Rather, the 2-year point is the point at which some kind of an assessment will be made as to the next steps. And that might be continuing with the system, expanding its functionality, or building some sort of a replacement. I think the key takeaway in relation to the RDRS system is to bear in mind what that purpose is in terms of the data generation. And it's therefore really important that requesters do use the system. Even knowing that disclosure is not guaranteed, and even if initial experiences with submitting requests via the system don't return significant numbers of usable results in terms of the data actually being disclosed. The number of requests submitted to the system will be taken as an indication of the demand for access to registration data. If the system's not used, therefore, this will feed the narrative that there's no problem with gaining access to registration data, and therefore nothing that ICANN needs to fix. And therefore, in the run-up to November, you're likely to see a lot of outreach from organizations like INTA and others encouraging you to use the system. And as I say, that's the key takeaway, that lack of use will be taken to indicate lack of demand and lack of a problem.